It gives us a little bit of a comfort break, so that's fine. Ms. Lucey, you may begin. This is the case of State versus Booker.
Good morning, may it please the court. My name is Martha Lucey. I am here representing Patrick H. Booker, Jr. The case originated in Dubuque County. The Court of Appeals issued a decision which Mr. Booker sought further review, and this court granted further review. I'm going to jump right in with the Batson issue because I believe that's why I'm here. The current Batson three-part test is insufficient to combat racial discrimination in jury selection. The application for further review noted that African Americans are disproportionately charged, convicted, and prosecuted in the state of Iowa. If prior involvement of family, friends, the prospective juror himself is a qualifying racially neutral reason for a peremptory strike, the state of Iowa is never going to move past having lack of diversity on juries. The fair cross-section cases are the first step. And as Justice Apple noted in his concurrence in Veal, that first step of requiring that there be a statistical portion of jury pools to have racial diversity is meaningless without the ability to somehow protect black jurors, minority jurors, prospective jurors from being struck preemptively under pretext or some other term of proxy.
Question. I mean, doesn't this case kind of disprove that? Because the trial judge granted the Batson motion initially, right? And then she went back and thought about it over lunch and changed her mind. But, I mean, that doesn't sound like a situation where the defendant has a set of circumstances or a situation they can't overcome. I mean, you can come up here and argue why maybe the initial determination was correct, right?
I think that the initial determination was probably correct. The determination, maybe the reasoning itself, does not stand up to the current case law. And I think that that's the problem, is that the current case law says that it's okay to use a peremptory strike on someone who has been involved with, law enforcement or a criminal case, or their family or friends have also. The state of Washington has moved towards trying to rectify that with a rule, and prior to the rule being passed in State versus Jeffries, the Washington Supreme Court said, we're not going to do this anymore because historically this has been a proxy for race. Any type of involvement with law enforcement. And then if you look at the state.
We have to follow U.S. Supreme Court precedent, correct?
You have to, to some degree, but in Batson, the U.S. Supreme Court gave states free rein to fashion a test that works for them. So, there's different states that have used sort of variations of Batson. Every state, is my understanding, every state but Washington follows some variation of Batson.
By a rule, right?
By a rule, and then prior to the state versus, I think it's Jeffries, I hope I have the right name, the rule was not in effect at the time of that individual's trial. So Washington didn't follow the rule because it was not effective, it wasn't retroactive, but in essence did the same thing that the rule does.
Batson, the theory of the case is that it is not a impartial jury or trial right. The theory of Batson is the lawyers and the parties have standing to raise an equal protection discrimination challenge on behalf of the juror, right?
And for the defendant.
Rationale that you're advancing here relates to fair trial rights, which the Supreme Court rejected in Holland.
What I'm requesting this court do is to require more than just saying that this juror has family or friends who had been arrested or convicted. I'm not saying that there isn't some other reasons based upon that conviction or their beliefs, or that it's not unreasonable to say that we're going to go ahead and strike this person.
Request for more square with the constitutional basis for the right, which is discriminatory animus, third party standing to challenge discriminatory animus against a juror. And that's wholly disconnected from any fair trial right, at least in the Supreme Court's jurisprudence. So why would we require more?
Because if the juror has a right to be, a prospective juror has a right to be evaluated on more than race, then if conviction and being stopped by police, being charged, being convicted, being incarcerated, which we know that African Americans in Iowa are disproportionately stopped, charged, arrested, incarcerated.
I mean, I may be of the view that this is worth looking at by way of a rule, but I do think what you're talking about is qualitatively different from Batson. So when Batson, U.S. Supreme Court said the prior law was not good enough, and I remember that well because I remember my con law professor in law school fought the battle to eventually get Batson. And what it said was we're going to adopt sort of a burden shifting thing where at least make the prosecutor come forward and give a race neutral explanation and then require the judge to evaluate it. But what you're talking about is, not instead of requiring the judge to evaluate whether something's a pretext or not, to actually sort of rule out certain grounds for striking jurors that belong to a protected class, say. And that's qualitatively different, isn't it?
Suggesting this court do is not change really step one and step two. It's at step three that there has to be more than, oh, well, he was arrested before, or he said that the police are
available under the current law. The judge can say, I don't believe that prosecutor. I think it sounds like a pretext. And, especially when we sometimes see the prosecutor lists, 8 reasons why they struck the jury, then sometimes me as a reviewing judge, I'm maybe more suspicious because if there was a good reason, you'd just give that one. You wouldn't give 8 reasons. So I mean, those are tools that are already in the trial judge's toolbox, right?
difficult with a trial judge to look at a prosecutor or a defense counsel, I mean, it can be both ways, as we know from State versus Moots, and say, I think you're being racist. I mean, that's really difficult for them to do.
Wouldn't they use the other language that is already provided for, is that I don't think you have shown, you haven't met your burden. I don't know, I don't think it's, I think that they know it when they see it. You're right, they may not come right out and call it that, but I'm kind of on the same line as Justice Mansfield, that there is an opportunity on that step 3 for the court to step in.
Opportunity, but they have to find a pretext. And if the prosecutor says, I don't want this guy because he has a family member who has been convicted of sexual assault, and this is a sexual assault, and anybody involved in a sexual assault case should not be on this case. And there's nothing more, then how do you go about the idea of Well, this strike of this juror, who happens to be black, is different than the strike to the white prospective juror who said essentially the same thing.
Talk about it in the abstract. I mean, on the facts of this case, you have a sexual assault trial, correct? And the juror says, I think my cousin maybe was falsely accused and convicted of sexual assault. I mean, to me, that seems very pertinent from the prosecutor's perspective about how this person may view the facts of the case, right? I mean, is that an unreasonable conclusion?
That if the prosecutor had explored more about this, instead of just continually trying to get him to change his mind that there are no false allegations.
Cousin?
Do we know the facts of the cousin's case? No. Do we know how close the defendant is with, or the prospective juror with?
Discriminated against because he was criminally involved, which is the argument you're making about excluding jurors criminally involved. He has a cousin, but we don't know the cousin's race. The cousin believes, or this guy believes, that his cousin was falsely convicted of sexual assault. You don't think that has any bearing on how that person would view the facts of this case?
He actually says he was falsely accused. I think he says that.
There's two sides to every story, and the facts, it seems like it was a party. It seems like it was pretty analogous to the facts that were at issue here.
That we can say it's analogous. I mean, the only thing he says is that it's a house party. And
I mean,
I'm going to ask some questions of Ms. Soich. I mean, I'm a little troubled about what's going on here. I mean, part of the problem is it just seems to me inherent in the nature of voir dire. I mean, nowadays, when we do these HR interviews, we ask every single person the same questions because, and that's not the way voir dire works. I mean, I don't know, clearly this prosecutor asked this particular juror a series of questions that to my mind, I didn't see being asked of other witnesses and, I mean, other potential jurors, excuse me. And that's, but I don't know, you know, how you address that in the context of voir dire, which is meant to be kind of freewheeling and other than allowing the trial judge to make the ultimate call whether they believe the prosecutor's explanation or not.
one of the jury selection, the prosecutor asked people pretty much the same thing. There was variations, and some, you know, he questioned them about their involvement or family involvement with sexual assaults or sexual assaults. Some he just asked no more questions of at all. Some he asked some follow-ups. Day one, near the end of the prosecutor's time, he just said, now I just show of hands, how many people here have been involved with Black Lives Matter rally? And don't read anything into that. It's not scientific. No follow-up with that.
By that line of questioning, I'm going to ask Ms. Soich about it.
Two comes, and the judge doesn't start with any of the preliminary questions about, has anybody been involved with assault, sexual assault? Do you know people? I mean, granted, there's 3 jurors that they're talking to at that point. But none of those preliminary questions. The prosecutor doesn't ask these 3 jurors on day 2 if they have family or friends. He just starts in with who deserves to be raped.
I mean, I remember trying cases myself, and I certainly watched a lot as a judge. That's lawyering. When you, if I wanted to, like if you were sitting in the box and I wanted you on my jury, I'm probably going to stay the heck away from you. I don't want you to say something that all of a sudden is going to tip off opposing counsel. Ooh, I don't like the way this is going. So isn't that part of just how a trial is conducted as well?
Sometimes they just have these gut reactions, but then they keep people that they've never spoken to and nobody else has ever spoken to.
They don't know anything about them. I mean, I was a prosecutor in a small town, small county, and I knew a lot about the people who were potential jurors, whether we talked about it in the box or not.
You know, they have juror questionnaires. They know some things about them, but they don't necessarily know, in Dubuque, they don't necessarily know who all these people are, depending on when they got.
Probably to the law enforcement or whoever might be associated, right? Show them the list of potential witnesses?
Early they got the jury questionnaires. And we don't know that answer here. I do know that this was early in the pandemic. My time is up, may I conclude? And that the trial itself was done under some difficult circumstances. And that day one and day two of jury selection weren't the same. I'd ask that you grant Mr. Booker a new trial. Thank you.
May it please the court. Good morning, Your Honors, Counsel. I am Soich, and I represent the state. Your Honors, we should not be here today to tweak Batson. We should not be here today to jettison Batson. We should not be here today to fix Batson because this issue was not raised. It wasn't raised below. It wasn't raised in the briefing. We have no ruling. What we have, Your Honors, is a claim that the trial court applied Batson improperly or came to the wrong conclusion about Batson. But I don't read anything in the defendant's brief or the defendant's further review which suggests that this court should take this opportunity to fix Batson. The court in Veal in 2019 was given the opportunity to fix Batson, and it was actually raised, where the Veal defendant said, I believe that the court should adopt a standard that when we have the last black juror who has been struck, when it's the only or the last black juror, there should be a heightened standard. And what this court said in Veal, in the majority opinion, was, no, that's not consistent with our case law. It doesn't have to rise to the level of cause. We don't accept that there should be any sort of tweaking of Batson. The court said that in 2019. But at least in Veal, Your Honors, the defendant asked this court to tweak Batson. And again, I don't read anything in the briefing as suggesting that this court needs to change step one, step two, or step three. And to that more global point, may I say that Batson does enable the court to make the kind of inquiry that we want it to make. We do have the three-step process, and Batson is sort of wide enough, broad enough, and flexible enough to allow courts to at least attempt to ferret out some sort of racism in the preemptory strike world. And as it's been suggested by Your Honors, it is sort of a freewheeling process when we have voir dire. We can't legislate everything. We can't kind of delve into every single motive of every single lawyer who's conducting voir dire. But what we can do is we can try by going through the three Batson steps. And
Far on that question about Black Lives Matter. There's not a lot of wondering and speculating where they were going.
Your Honor, I can't really, I'm not sure about the Black Lives Matter question. Black Lives Matter obviously doesn't just impact black people. There are plenty of white people who agree with Black Lives Matter movement.
That is a questionable question to ask on voir dire. Have you ever attended a Black Lives Matter rally? If I was a black defendant facing trial, I would really be bothered by that line of questioning.
I think it would certainly get your attention, Your Honor. But it wasn't as in, I think, Silas versus California, where they really made the point that it was sort of a lawless, that Black lives, I believe it's Silas, I could be wrong on this, but one of the cases where it certainly wasn't to that extent. It was a quick thing. What really, I think, this prosecutor's focus was much, much more was the whole rape culture myth. This case was awash in rape culture myths, Your Honors. What we have is we have this young woman. She contacts these men she hasn't seen in 6 or 7 years, invites them over for the tattoo party. They're going to have sex. They're going to probably have a menage a trois. Again, this woman has every right to make those decisions, every right in the world to make those decisions. But the prosecutor was quite rightly concerned that not every juror would think that, and that the prosecutor had to combat this. these biases or prejudices that jurors could very easily have about these facts. So both days he starts out, does anybody deserve to be raped? His closing argument, his opening statement, over and over again he's saying, you shouldn't blame this victim. This victim can make all kinds of decisions that you might not have made, but when this victim says no, no means no. And I think it's hard to review this case without really keeping in mind that this is a very strong example of all the rape culture myths. So that's why the prosecutor asks this. And then when we get to juror 30,
If that's right, then why this additional talk about, well, this juror works at night, and the judge says that the juror doesn't have to work nights during this trial, that she'll give him a note, and yet that's still sort of used as kind of another reason for it, right? It has this sort of, it has this smell of a pretext when there's this other rationale given for it, if all that you said is enough.
Your Honor, I would say that lawyers, like everyone, probably want to err on the safe side, and we never know exactly what reason someone might find persuasive. So if there are truly several reasons, we're probably going to say them all. However, the prosecutor in this case specifically said, after they talked about the working third shift, the prosecutor said, but more concerning to me is the idea of this, there's two sides to every story, that the cousin has been incarcerated. And I would note that these facts are extremely similar, the facts that we know. We don't know all the facts. But the facts that we know is there's a house party, my cousin and four or five men have sex with a girl, he says, 4 or 5 men have sex with this person. He gets 50 years in prison. Well, who's to blame there? Do you blame her? Do you blame your cousin? I think they're both to blame. I don't know a prosecutor in the world who is going to leave that potential juror on the jury. So I do see your point, and as Justice Mansfield said, if there's a complete laundry list where they're just coming up with everything, and plus they didn't really look me in the eye, and plus they seemed uncomfortable, and they're adding all kinds of reasons, that might cause you to think, why are there so many different reasons given?
It could cause me to say, and did you attend a Black Lives rally? I mean, I agree with you. I remember, I think some of the hardest cases to prove are maybe OWI 1, because there, but for the grace of God, a lot of potential jurors have been in that situation. And so I was very careful picking juries to make sure that that wasn't going to be a problem. And so I understand that, but I guess the link is what's bothering me. And the question that Justice McDermott brought up, the court seemed to salve that, and yet that was used as the reason. So I think that makes the question about Black Lives Matter stick out like a sore thumb.
But in terms of the juror and the work schedule, it wasn't really clear to me in this record exactly whether because he responds, well, I work at Bimbo and they just want a body there and it doesn't really matter. So I didn't know that if he thought even if he gets the excuse, he's still going to try to go to work and then be exhausted. He did say, I haven't gotten any sleep. I got off at 6:45. I haven't even gotten home yet. So, I mean, that may be a reason, Your Honor, but really, I think once we got into my cousin is doing 50 years, then I think that's really where our focus should be, because that's clearly what this prosecutor was concerned with. And the prosecutors...
When we're doing the pretext analysis, how much should the court have at least considered kind of where the prosecutor was coming from when he asked about the Black Lives Matter, and does that kind of taint at all the explanation? And so when you're looking at pretext, if we've got some maybe discriminatory reasons going on or something that we don't believe, like the work issue, but we've also got maybe a potentially valid, how do we, on step 3, under the current Batson framework, how do we weigh those out?
Current Batson framework, we look, was it in substantial part a motivating factor, discriminatory intent? And I think that the Black Lives Matter thing was brief. It really wasn't the focus. And the trial court didn't really make a step 3 analysis. It sort of collapsed the steps a bit anyway, but the court, I think when just looking at the fundamentals of why this prosecutor said that he wanted Juror 38 removed, and the fact that it would make perfect sense for Juror 38 to be removed because Juror 38 would show some degree of bias and the tendency to engage in the victim blaming and all of that. This was,
It's all how the questions are worded. I agree that statement was made. The prosecutor's fishing for that. The prosecutor says, who do you blame more in that status? So do you think the woman was kind of at fault for being put in that situation? I mean, yeah, at fault. So the prosecutor's kind of, fishing for the response. As soon as he gets the response he likes, moves on. And it's, this is maybe a problem with Batson. I agree. It is what good lawyers do.
every day during voir dire. And there was another instance where with Juror 38, he's talking about, well, what if and Juror 38, I might add, Your Honors, introduces the concept of the booty call 3 times. The third time, no one's even talking about any specific facts, and they're asking him, would you be the type of juror that just goes with the flow? And he says, no, I wouldn't. For instance, if we have a booty call situation, then he goes through this whole example, and he's already talked about that twice. So it wasn't even really responsive to the question, but Juror 38 is asked, well, what about if somebody comes to their house, it's late at night, there's alcohol, and something to the effect of, what if there's touching going on? And then she wants it to stop. Should it stop? And he says, yeah. And then the prosecutor says something like, okay, or all right. And then Juror 38 says, I guess it would have to. And again, it's a small thing, but it's clearly something that a lawyer is going to look at to try to inform his or her decision about whether this particular juror would have some bias or prejudice. So instead of saying no means no, he says, I guess it would have to stop. And that's on top of all of the other conversation that Juror 38 and the lawyers have had. So we ask you to find that in this case, there was no pretext. This was a legitimate race-neutral reason. And we also ask you, Your Honors, to not take this opportunity in this particular case to do something big with Batson, because it has not been requested. Even in Veal, Justice Apple's opinion says, well, no one's asked us. There was some talk about getting rid of peremptory strikes altogether. Justice Apple says, no one's asked us to do this, and that would be a substantial undertaking, of course. And I might add, it probably wouldn't be something that this court would do directly, but through the rulemaking process, even if it were inclined to. But this Rule 37 in Washington, not a good idea at all. I see that my time is ending relatively quickly, so I want to say before I forget, if the court is at all inclined to do this, I did find a Montana case that in the dissent contains kind of a survey of what other courts are doing. I'm certainly not encouraging you at all to do anything with Batson right now, but if you are inclined to wonder what other states are doing, this Montana case is called State versus Well-Known, WELLKNOWN, state, and I think it's 510 P 3rd 84, but in the dissent, the court says, well, several state Supreme Courts have initiated task force to look at this very issue. I think North Carolina, Connecticut, they talk about peremptories being eliminated, perhaps in Arizona and maybe New York, thinking about it. Again, I am not encouraging that at all, but to the extent the court might want more information, I would point you there. In this case, Your Honors, the Court of Appeals got it right. The district court got it right. There was no discriminatory intent by this prosecutor in striking juror number 38, so we ask that you affirm. Thank you.
I'd like to go back to a couple points that I did not make on my opening argument. The Court of Appeals found that Mr. Booker had not even established step 1. In State versus Moots, this court held that if the prosecutor does not say, well, no, there hasn't been a prima facie case made, but instead explains the reasons for the strike, that the court is no longer has to find that first step. We're already on step 2. So for that reason, the Court of Appeals' opinion is wrong about step 1.
Can you respond to Ms. Soich's point? As I read your brief, there was no request to modify Batson, to do anything different. It was a very straightforward argument that the straightforward application of Batson on the facts of this case. And it seems like your further review and the things we're talking about here today, while maybe of some academic interest, were not ever raised in this case until now. Can you respond to her point about that?
In fairness, I didn't write either the brief or the further review. And in the brief, I agree. I don't find anything there talking about Batson's shortcomings. In the further review,
Can we even address this issue? It wasn't briefed. It wasn't in the main brief, the reply brief. This is like a free-floating kind of discussion about something that's never raised or argued at any point until today, now.
further review on page 10 and 11, prior counsel did say, asking a black juror if he had familiarity with criminal cases of this type is discriminatory because black jurors are far more likely to know someone involved in the criminal justice system than are non-black jurors.
Request to modify Batson, change Batson, do something different than, like, I'm fairly confident that the facts of this case do not violate Batson as articulated by the U.S. Supreme Court. I think the only way you get there is if you are asking us to do something different, and I don't see that request made at any point in this case.
That the request was not explicit in the further review, but I think that it was raised that fairly I can get up here and ask you to do that.
For the review, we don't normally allow you to add new issues because the state doesn't, as you know, doesn't normally respond to applications for further review. And Ms. Soich seems very well prepared today to talk about Batson, but that's to her credit. I mean, she wouldn't have known that from reading the briefing, really, right?
From the briefing, because Ms. Soich is well-versed in further review, because both the state and defendants frequently tweak their argument in applications for further review, and this court addresses them. If there's issues about, not having full briefing, the court asks for supplemental records. I mean, there's another case that my office has where the further review has been granted, and this court asked for supplemental briefing on a specific issue. I don't think you have to fix Batson, which Batson needs fixing. I mean, I think maybe you don't all agree with that, but Batson needs fixing. On this record, using Batson, you can rule in Mr. Booker's favor. So let's talk about what two sides to a story. How is that offensive? Don't we want jurors to look at both sides? Isn't that exactly what jurors are supposed to do? There's two sides to a story. Oh, no, there can't be, because there's only my side.
I mean, no. What we want to do is have the advocates use their strikes in a way, I assume, that they're picking a jury that's most favorable to their case. And so if I'm a prosecutor and somebody says, I'm aware personally of a case where somebody's been falsely accused and is serving time, I would think it would almost be a dereliction of the lawyer's duty to not do something. So yes, as a court system, we want jurors to be open-minded. We want them to be fair, but the purpose of the peremptory is to shape the jury in a way that makes it favorable to that case. I understand your point about Batson. It's why it's fundamentally flawed. It says we can't pretend that people have different views about the evidence in the case and that we can't use these heuristics to weed them out. But then we're only arguing about it because we know it matters. You know it matters. I know it matters. People view the evidence differently. So, yeah, I don't think it's right to say that the lawyers are trying to pick people who are down the middle. They're trying to pick people who favor them.
All right, I'm out of time. May I respond?
Go ahead.
I think if you look at the rest of the jury selection, especially day one, both lawyers talk about, we want somebody who's going to be fair to both sides. And you see that a lot. Will you follow the instructions? Yes. Can you set aside that prior experience? Yes. The prosecutor never asked Juror 38, can you set that aside? Is this a firm belief? And Juror 38 never, and I'm going to disagree with you here, he never said his cousin was falsely recused. He said that his cousin was to blame too. And he is only hearing it from his cousin's side. We don't know anything else. And I'm not here advocating for eliminating peremptories. I know that was not done in the court rules. But we need a better way of being able to say these peremptories are not just secret, excluding people of different races, especially when the defendant is black, the victim is white. And I will disagree that the entire case is rape myths until the jury says the victim, the complaining witness is a victim. She's a complaining witness. So rape myth doesn't belong here. And I've gone beyond my response. I would ask this court to reverse Mr. Booker's conviction and remand for a new trial. Thank you.
To both Ms. Soich and Ms. Lucey. The court will stand adjourned for about 5 minutes, and then we will reconvene for the case of Valdez versus West Des Moines Community Schools.